Hello again. This is Kato. I am going to be covering the next aspects of the program regarding performance management and terminations of employees. And we're going to start off today with respect to the topic here of keys to performance management and move on from there. So again, I am Kato. I am the owner and operator of my own law practice here in San Francisco, advising employers in all aspects of employment law. So why should you, the employers and human resources professionals in the audience out there, even care about performance management when in the previous part of the program I mentioned to you the notion that employment is terminable at will without cause or without prior notice and opportunity to improve? Why should you care whether your managers are doing a good job in managing subordinate employees who are having performance issues? Well, the short answer to that question is that this is a function, and it flows from how the courts and the arbitrators who handle employment litigation disputes, such as claims of discrimination, wrongful termination, and retaliation, will assess and decide these cases. Now, first of all, in all of these cases, it is the employee who carries the burden of proof. Now, that means that the employee has to establish a legal violation. For instance, that there's been some form of employment discrimination, or that they have been wrongfully terminated or retaliated against for having complained about some form of public policy violation. Now, the courts, however, recognize that it is rare in this day and age that the employees will have concrete smoking gun evidence that, for instance, the employer discriminated against him or her. And I think it's fair to say that no manager in his or her right mind in this day and age would, for instance, tell an employee as part of a termination meeting that I am firing you because I don't like blacks, or I don't like women, or whatever protected category you want to put into that sentence. Accordingly, since that type of smoking gun evidence is so rare, courts will allow the employees to prove a case of, for instance, discrimination based on what the law calls circumstantial evidence. Now, what does that mean? Well, it means that the employee is allowed to bring forth evidence that whatever reason was stated by the employer as the basis or the reason for the termination was in fact a lie, and that the real reason for the termination was, for instance, unlawful discrimination against the employee because of, for instance, his race. So what actually will happen in a litigation matter is that in a jury trial, the court will give a standard instruction in all the states of this nation, if there is a discrimination lawsuit, that if the jury concludes that the employer lied about the reason for the termination to cover up the real reason for the termination, the jury may find for the employee that the employer discriminated. So let's give what I've referred to as the common scenario. Now, this may not actually be that common, but in my years of practice, and I've been doing this for several decades, this is actually not that unusual, and let me explain it. So a manager comes to you, and let's assume that you are the human resources or the next level manager in charge of this particular manager's operation or department. And this manager tells you that he or she can no longer tolerate a subordinate employee's performance problems. Now, you know from your, let's say, years of managing this particular manager and this department that this employee's performance problem has been of many years' duration, and that this manager has not taken appropriate actions to address the subordinate employee's performance problems in the past. But now, this manager has come to you and said, I can't stand this employee's performance problems any longer, and I want to fire that employee now, immediately. And you also know, because of your knowledge of your company and operations and its employees, that the subordinate employee in question, who this manager wants to fire, is, for example, a minority, she's female, she's age 40 plus, and disabled. So if you're the manager and you call me up as the lawyer and ask for advice on, well, how should we respond to the manager's desire to terminate this employment relationship? One of the questions that I will ask is, well, have you taken a look at this employee's personnel file and tell me what that personnel file reveals with respect to this employee's performance problems from the past? And you've done your homework already, and you've gone through the employee's personnel file, and this personnel file shows no written record of dissatisfaction, or at least what a judge or a jury would consider dissatisfaction with that employee's performance. So, as mentioned in the slide, let's assume that the file shows no written warnings, and in fact, there's no negative performance review identifying dissatisfaction with that employee's performance. So, my next question, and I would have some further questions about this before advising on whether to go forward with the termination or not, is I suggest, well, apart from the personnel file, what other facts are there with respect to recent communications with that employee regarding the poor performance? And again, you've already done your homework and you're able to respond back to me that, well, frankly, what we have here is an absence of communications with the employee about poor performance. In fact, there are facts that reveal inconsistency with the conclusion that the employee is a poor performer. In fact, she has received a recent bonus or bonuses for good performance. There was also a recent stock option or other equity award that was granted to the employee. And in fact, there have been some email communications from the manager telling the employee that she is a good performer, or that there are other positive comments about her performance. And to top it off, she received a recent promotion as an indicia of her ability to perform not only her job, but in such a good fashion that she was granted a promotion to a higher level position. So if we went ahead and we meaning that in terms of the advice to the company that I would give and the employer's conclusion as to whether or not to terminate, let's assume that the employer went ahead and terminated this employee who is a minority, female, age 40 plus, and disabled, and where the personnel file and other records show no expression of dissatisfaction with her supposed poor performance. If she brought a lawsuit for discrimination, she is going to present all this evidence about her positive good performance, and the employer will be defending that litigation by offering the supposed evidence from the manager about her bad performance. Now, one of the first things I have to say is that there is no chance of this litigation being dismissed before a jury trial. Now, one of the first things that employers will try to do in a litigation is to get the court, to convince the court to dismiss the lawsuit by way of what's referred to as summary judgment, meaning that the court can summarily dismiss a lawsuit where there is no factual dispute about what led up to the termination, and toss the lawsuit where the employee has no evidence of discrimination to support the lawsuit. Well, in a case like this, there is no way that the lawsuit can be dismissed because we already know that there's a dispute based upon the employer's own records as to whether or not she was a good performer or not, as to justify her termination for unsatisfactory performance. So she will be saying that she was a good performer based upon her records in the employer's own files, and controverted by the employer, who will be saying that the employee was a bad performer. And in a situation like that, it's simply going to have to be decided by a jury as to who is to be believed, the employee or the employer. Now, as I explained previously, in a situation like this where a jury has to decide the case, that jury is going to be instructed that how to determine if the real reason for the termination was discrimination or not, is that if the jury believes that the employer lied about the reason for the termination, then the jury may conclude that the employer lied to cover up the true unlawful reason for the termination. For example, in this case, discrimination against her. So in this type of a situation where the records of the employer's own personnel file and other indicia of performance show that she, the employee, was viewed as a good performer, there is a substantial risk in this type of a setting that the jury may conclude that the employer did not terminate the employee for bad performance, and then can reach the conclusion, in agreement with the employee's claim, that the real reason for the termination was an unlawful one, such as termination. So, what's the solution to avoid this type of legal nightmare? Well, the answer is in this slide, which is to establish a sound performance management system which will solidify the notion that, in fact, this employee was not a good performer, she was an unsatisfactory performer, and then defend the litigation in this type of a litigation on the basis of your records, your own records. Now, before getting into these, for instance, the performance review factors that are listed here, one of the things I want to explain that I assume everyone in the audience is or has been an employee at some point in his or her career who has received a performance review. Now, even when the performance review is a positive one, I think many employees will candidly respond or tell employers that they dislike this entire review process because of the anxiety caused by that review process, both before and during the process. Now, some employers would conclude from that, well, I don't want to put my employees to this stress and anxiety of going through performance reviews and this entire process, so I'm just going to jettison performance reviews as part of our management process. Now, if asked about that, I would respond that providing regular evaluations has a legal benefit, and also from a practical perspective can actually be good or a positive for employee morale. Now, how I would explain that is, what kind of message does an employer send to its employees when it is unwilling to invest the time to provide performance feedback on a regular basis? Employees who fail to receive regular feedback may tend to feel frustrated by not having enough information about where they stand and feel that the employer is simply not willing to invest in their long-term development. So, contrary to the belief of some employers that providing candid performance feedback creates morale problems, I call this the no news is good news approach. Instead, I would suggest that failing to provide candid performance feedback may create an even greater employee morale problem, particularly as to employees who are more conscientious about their performance. So having said that, then if you, the employers in the audience, decide, okay, we are going to have a sound performance management system that includes performance reviews, then I've listed here what I consider to be hallmarks of a good performance management review process, which means that they should be accurate, and that means to me of having no sugarcoating, and more about that later. And that should mean that you acknowledge the good, the bad, and even the ugly, to use an analogy or words from an old Clint Eastwood movie. I also stress that they should be fair in their assessment, and easy to understand. And I would definitely recommend that they should be factual, meaning that there should be specific factual examples of what the employer is trying to communicate, and that this should be stating more than what I refer to as a mere conclusion. So, what do I mean about providing examples versus specific facts? I've listed here several examples of what I would consider to be conclusions versus a statement of fact. So one example is with respect to, let's assume your subordinate employee, Betsy. Betsy is not a team player. Now that's the conclusion, but what does that mean? Well, the fact supporting that, which is what should be identified in the performance evaluation, is that, for example, Betsy was the only employee in the department who didn't volunteer to help on this particular project. And she, as a reason, gave that that's not in my job description. And the second example I give here is of subordinate employee Paul. And the conclusion is that he deals with coworkers in a somewhat abrasive fashion. Well, the fact in support of that is that Paul raised his voice to Jane in a meeting on such and such a date and said, "Screw you, that's your job." So it's perfectly okay to state the conclusion that you're trying to communicate to the employee, but it's also important and necessary to provide specific facts by way of explanation and an example. All right, so at this point, we will reconnect the next day to talk about the topic of sound performance management.